Hello, everybody. Hello, welcome. I have a very quick overview I thought I would help a few people with today. Welcome, welcome. Welcome. I am set to go live later tonight with a specific topic, but I wanted to just hop on here just for a couple of minutes, not for too long, but to talk about the First Amendment and criminal law. Hello, welcome. I just have been tagged and asked so many times about the First Amendment when it comes to criminal law, and I just wanted to come on here just real quick and kind of explain a few things just for clarification purposes. There has been so much discussion going on about the First Amendment when it comes to criminal law and whether or not you can just kind of use the First Amendment and how the First Amendment would protect you from any kind of criminal law issues. And I really wanted to just spend just a quick amount of time here going through a couple of tips, ways to understand how this process works. Yes, hello, welcome. Yes, I'm just getting started here. I'm not going to spend too much time on this, but I think it's just so important. I wanted to just share. I've been talking a lot about the Brandenburg versus Ohio test when it comes to inciting violence, when it comes to the First Amendment. And that's a valid test. That's a test that we've used repeatedly over time. But I want to actually step back further than to even before the Brandenburg test. And let's talk about this First Amendment. Congress shall make no law. So the first element to the First Amendment is with regards to a law. So if there is not a specific law involved, we're not talking about the First Amendment. So shall make no law respecting the establishment of religion or prohibiting free exercise thereof or abridging the freedom of speech. So no abridgment of the freedom of speech. So that's the First Amendment language. Hello, everyone. Hello, welcome. Thanks for joining me. This will be a quick one. I've got a live schedule for later tonight, but this was so important. I thought I would just talk about it here just for a few minutes. So, no, I do not. I do not really claim any, under my state rules of ethics, I don't claim any specialized area. Oh, thank you. Thank you so much. So we've been having this question that's been going around quite a bit about the First Amendment. Okay, so let me just break it down as quick and easy as possible here. What I've pulled is Title 18 of the United States Code, and this sets out our criminal procedures. Yes, I am not going to do anything regarding religion whatsoever. So, thanks for asking, but that's not really not really my bag. So, Congress cannot choose for you to join a specific religious organization. Yeah, I'm not really getting into a religion, although it's a good question. But yes, hello, Norma, welcome. Yes, not really going into religion today, but I do want to talk about. Yes, it's true. It's in the First Amendment. But what I want to talk about here, just real quick again, is this freedom of speech. There's so much talk about freedom of speech and how someone cannot be charged because of freedom of speech. So what I've done here is I've pulled the Chapter 18 of the U.S. Criminal Code, and it just sets out some crimes here. And I want to go through these crimes and talk about which crimes involve speech. All of these can be charged at a federal level. So I'm just going to take a few minutes here and let's kind of review this. Let's talk about this. So we've got the first one here is arson. So we know that arson, of course, is intentionally setting something on fire, right? So if you are to do an attempted arson, you could have language involved in that in a conspiracy. So that language used would be part of the offense that was charged. So you wouldn't be able to say, I've got a First Amendment right to, say I want to commit arson. No, you don't. You don't. That's not how the First Amendment works. So that's for arson. But really, I think the best example to illustrate this First Amendment and how it works for criminal justice is assault. Most people think of assault as a physical altercation, but that's not true. An assault doesn't necessarily need a physical touching or an unwanted touching. That's part of it. It could be a battery, but an assault can be threats. Now, let me pull out the section of the code I'm talking about here. When we're dealing with an assault, I've pulled out code sections for first of all, we've got the United States Code right here. So an assault defined. Hello, welcome everyone. Just doing a quick explanation of the First Amendment in criminal law here. An attempt with force or violence to do a corporal injury to another may consist of any act tending to such corporal injury, accompanied with such circumstances as denotes at the time an intention coupled with the present ability of using actual violence against the person. So this is a definition set out in federal law, meaning you don't actually have to touch somebody to be charged with an assault. Your words and the ability for you to go forward and possibly harm them is enough for a charge for assault. So I'm using this particular crime as an example to just say we can use words in a criminal way and be charged because of that. Okay, so I think assault really is the best example. So this is the federal code. It's saying if you're threatening someone and you are in a position where you can follow through on that threat, you can be charged, even when we're just talking about language. Now, let's not just look at the federal government. Let's look to Florida. I think Florida is always a great example. Yes, an immediate threat, right. If you're standing in front of someone and you're saying language that's threatening and they perceive that as a threat and they are afraid, that can be seen or charged as an assault. So under the Florida law, an assault is an intentional, unlawful threat by word or act to do violence to the person of another. And again, I bring this up because we've got this threat by word. So language, speech itself can be codified under criminal law. We have plenty of crimes that involve speech in and of itself. So when someone says, I have a First Amendment right to say whatever I want, to some degree that's true. But according to the law, there is speech that can be regulated and criminal. And again, I'm using assault, I think, as the perfect example to say an unwanted touching is an assault, but also a threat of harm with the ability to follow through on that threat is also an assault. So you would not be able to come into court and say, well, I just said my First Amendment right. I just had freedom of speech to say whatever I wanted to another person. Nope, you can't. Under the statute, under the law, an unlawful threat by word, and then with that ability to follow it up if you had wanted to, that is unlawful. So those words are unlawful with, again, that ability to back it up. So again, just as that example to show, when it comes to freedom of speech, we have limitations, and our criminal code sets those limitations out. Now, this one is hard. It's always hard to find Louisiana law, but this is the Louisiana Code section here, and they define assault as an attempt to commit a battery. A battery means an actual unwanted touching. So an assault does not involve a touching. It's an attempt to go forward and commit a battery, or the intentional placing of another in reasonable apprehension of receiving a battery. So language that can be used to place someone in fear of a potential assault, of a potential harm to their person, could be seen as an assault, and this is the Louisiana Code. Now, this is not legal advice. This is just basic tenets of criminal law. When we teach criminal law to any student that comes in, we're not giving them legal advice. We're just telling them how the law works, which is completely acceptable if you've got the proper credentials here. So this is for Louisiana. So we have Florida that's saying words, if you can follow that up with that fear. We have Louisiana that said the same thing, but let's go to Texas. Let's look at Texas and how they define an assault, because I think when you're thinking about Texas, you can kind of think of how they are going to go about their code sections so carefully. So a person commits an offense if the person, A, intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse. So we've got subsection 1. We also have subsection 2, intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse. So this is the language. An assault in Texas could be a threat. It could be language. So when, again, we're talking about speech, it is possible to be charged with an offense if your speech violates the criminal code. And that's really what I'm trying to really clarify for people here is that freedom of speech is not something you can just say and do whatever you want. No, you can be charged with assault just by using your words and having the possibility of harming someone and placing them in fear. Our intent is recklessness, and that was under the Counterman case that was just decided by the U.S. Supreme Court a couple weeks ago. But this idea of threatening another person with harm and being able to follow through with that harm, even if you don't touch them, you can still be charged with assault. That's how criminal law works. Those are the basic tenets of criminal law. So, I wanted to share that. Again, we've got Texas here, we've got Florida, we've got the federal code. All of these code sections go into how your words can be charged. Freedom of speech is not going to protect you if you are committing a criminal offense. And so that's why, I really wanted to hop on today and explain that essential element. I have been going through the Brandenburg test, and the Brandenburg test is that imminent lawlessness test, and it's a key piece. But that's only if there's a statute that has been written that someone's claiming is impeding on their First Amendment rights. So that's if we've got a statute saying you can't talk, we're going to take a look at Brandenburg. But it's also how the law works. And again, we have within our laws, we have crimes where if you use certain words in certain ways, you can be charged. That's just how the law works. Right. Freedom of speech is not going to protect you if you're committing a criminal offense. Exactly. Yes. My rights end at the tip of your nose. Yes. That's a basic criminal law tenet. And I feel like it's kind of being confused just a little bit recently. And so I really wanted to take a step back and really go through this. So just as, another way of explaining, so we've talked about if you're attempting arson, your words could be used to charge you with a conspiracy because maybe you haven't burned anything down, but the intent is there, and to conspire means two or more people. Just because you didn't do it doesn't mean you can't be charged with it. An assault, we've got that. If it's threatening language and someone's in fear, yes. Bankruptcy crimes, so if you're putting fraudulent information in, bribery, graft, conflicts of interest, all of those involve different levels of speech. If we go over to civil disorders, civil rights, those are lots of times those can involve speech as well. Coins, currency, that can involve speech depending on how there's fraud. Conspiracy, again, we don't necessarily have to have the crime to charge conspiracy, but the language to commit the crime is can be used as an element of that conspiracy. Contempt of court. If you say the wrong things in court and the judge has admonished you, you can be charged just for your language. If you go into court and you're like, you know what, Your Honor, I think you are blank, 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 and the judge can say, don't say that again, and you say it again, that judge can put you in jail for contempt. Now, you can say, I've got a First Amendment right. That's not going to help you because there is law regarding contempt. Contracts, if we've got fraud, counterfeiting, and forgery, that's all speech. Customs, elections, political activities, there's certain restrictions that we have on that. Embezzlement, theft, those can involve speech. Espionage and censorship, that's all speech covered under the First Amendment. But if you break this law, your speech will not be protected by the First Amendment. Extortion and threats, there's a specific crime just for extortion and threats, which, that is speech. So that freedom of speech, of course, is not protected. False personification or personation, those kinds of things, forfeiture, fraud, false statements. So there's an actual crime called false statements, which are words, literal words being used that you can be charged criminally for. So there's tons of it. There's tons of it in here. Mail fraud, malicious mischief, obscenity. Obscenity is almost always some kind of speech. And again, not just words, but expressive kinds of speech, just not protected. None of that is protected by the First Amendment. Obstruction of justice, which I think we're all getting used to what that means. This particular section of the code, that can involve words being used in order to obstruct a particular proceeding. And so on. So perjury, again, is very specific to language. So I won't go through every single crime here, but I'm just trying to illustrate what we have here for all of these different kinds of crimes that have an element of speech involved. And you can be charged with a criminal offense because of something that you said. Yes, obscenity can be a crime, as long as the statute is written in a certain way that follows the test that we have on obscenity. But yes, obscenity can be regulated and is not protected by the First Amendment. Absolutely. So, I'm hoping to kind of, taking this step back to look at the First Amendment. This is an example of the federal code, just because I couldn't pull all the states, but for this example, again, of assault, I did pull the Florida law, right? An assault's an intentional, unlawful threat by word. So there's speech right there. So threat of violence can be an assault. This is Louisiana, an attempt to commit a battery. So a battery is an actual unwanted touching, but the assault is the threatening words leading up to the battery. Intentionally placing another in reasonable apprehension of receiving a battery. That language that's used to put someone in apprehension of being harmed is technically an assault in Louisiana. That's how their code defines it. Also, again, here's Texas, and they've got multiple pieces. I only printed out the first of 20 pages, but here they've defined an assault. Yes, an intentional, knowingly reckless causing bodily injury to another, yep, number one. But number two, intentionally or knowingly threatening another with imminent bodily injury. That threat, that language can be charged as an assault in Texas. So that's how our criminal justice system works within the confines of that First Amendment. Right. I mean, again, we're not just saying, oh boy, I really am frustrated with my spouse. They should, whatever. No, I mean, you need to follow that up with the actual ability to follow through. Sure. But, we're looking to the totality of the circumstances. So if there are words putting someone else in fear of harm, and you're standing there and you have the ability to come at them with a level of harm, you're going to be charged, even though you're using your words. And the First Amendment just does not protect you that way. That's not how the First Amendment works. Yes, I'll be putting this up on my Tube of You channel. I do put almost all of my lives up if I've got a good recording that everyone can see and understand. So I do put those up. So define, inflict pain, injury, or damage. Yes, every code section will define it themselves. You look to the very beginning of whichever jurisdiction you're in. This just happens to be the federal jurisdiction here because there's, we've got 50 states. But you look to the beginning of whatever section you're in, and they will go into the definitions of what different levels of injury are and so on. That's how we really define things. I've not gone into Brandenburg. I will do a full post on Brandenburg just to clarify, but I wanted to take us back further to actually before Brandenburg, just this idea that speech can be charged. It can be part of a crime. And you cannot use freedom of speech to protect every single word that you say. If there is a crime involved, and here I was giving examples like conspiracy for an assault, extortion, fraud, false statements is its own category, obscenity, obstruction of justice, perjury. All of these are crimes involving speech as one of the elements essential to the crime. So that's really what I've been going through here, is just kind of establishing that. Now, once this seems to catch everyone, once you nail this down, then we will get into Brandenburg. But I think even the Brandenburg test, the imminent lawless test, is beyond where people need to go to start their analysis. The analysis is here. Are there crimes where speech is an element? And the answer is yes. Speech can be an element of a criminal code section. So that's what we're dealing with here. When we talk about, and again, our criminal codes are, passed by our legislature. So whoever you vote for, that's who drafts the codes. They are the ones in charge of how the language is written. So, again, just a friendly reminder, if anyone is saying, oh, it's freedom of speech, that is not a criminal defense, affirmative defense that is plausible, because there are so many crimes that involve speech as one of the critical elements in the crime. Yes. Yes. Fraud is a great example. And we have fraud in all states and all territories. False statements are illegal. That is speech. And you could say, oh, I was just saying whatever I wanted, but you cannot say whatever you want. You've got to follow the law. And our law has restrictions on it when it comes to saying fraudulent and false statements. We do have those kinds of questions. Of course, fraud has to be proven just like any other crime. Why were we only taught the first 10 constitutional amendments rights in high school? That's a great question. Yes, slander is an excellent example. Defamation. Yeah. Yep, absolutely. It depends on the context. Freedom of speech is freedom too. Okay. Could be for some people, I guess. For some people. But these are just the basic tenets when it comes to criminal law and the First Amendment. Can you be charged with the speech you're using? Yes, you can. It depends on how the code section is written. How is the law defined? Did your words violate the law? If they did violate the law, you can be charged with the crime. Right. Inciting violence is not protected speech. And that's where the Brandenburg versus Ohio test comes into play, is because the U.S. Supreme Court has said, the incitement doctrine, which if you are inciting a situation for violence, that First Amendment will not protect you, just like obscenity. If you have obscene materials that are defined as obscene by your state code, you cannot say, I've got a First Amendment right to these materials. That's not how obscenity law works. Obscene materials are not protected depending on how your statute's written. It's the same in state. It's the same with how it works at the state. This is the section of the United States Criminal Code. This is Title 18, and it's just the beginning part to kind of set out some of our crimes, just to list as examples of crimes that involve speech that can be charged. The intent and the utterance, very important, but you look again to the elements of whatever crime you're looking at. So, for example, with assault, the elements could just be a threat with the ability to follow through with the threat. Words alone are not typically going to be enough for an assault, but the ability to follow through on the threat that you're making, that goes into that imminent lawlessness element that they're looking for in the Brandenburg test. So, in Florida, they define assault as unlawful threat by words. So those words themselves can be used as an element towards charging an assault. So that's how it's going to work in all of the states. That's just one of those basic principles, tenets of criminal law. This is Louisiana, again, an attempt to commit a battery. So the intentional placing of another in reasonable apprehension, that could be by using your words. Along with the ability to follow through with that battery. And then here's Texas, intentionally or knowingly threatens another with the imminent bodily injury. So the threat, the words, are the act involved in the criminal conduct. So these words are not allowable. That First Amendment won't protect you. Yes, and when it comes to intent, that's what in assault, that's really what the fight is typically about when we go to trial for criminal trial for attempt. We fight that out like, well, that was not my intent. And that's the Counterman case that just came out of the U.S. Supreme Court, where they said based off of the statute, it wasn't clear enough. And so Justice Kagan came in and said, we need a recklessness level of intent when it comes to your understanding of if your statements were perceived as threatening. Those kinds of things, we always are going to argue those about it. But again, it's those statements, that speech that is used as part of the criminal charge itself. Does that apply to millionaires? Well, it's supposed to. It's supposed to apply in the perfect sense of how things are supposed to work. That's how it's supposed to go. But so hopefully that's been a little bit insightful for people. Can a statement to incite violence contain verbiage like peacefully? Absolutely, it can. Absolutely. A statement in violence, there's no particular words, and I guess legally or the Supreme Court, what they tend to use are called words like that, magic words. And you can look that up. That's a legal term where a particular statute or there's a particular requirement for an exact word. And you know, peacefully is not a magic word that protects you by saying, if I just say the word peacefully, now it means I'm not inciting violence. It doesn't work that way. The language does not work that way for inciting violence. So you can put whatever word you want in there. You can say, you know, hey, I'm just kidding, or hey, this is off the record. Any of those kinds of statements, and try to mitigate the damage that you're intending to do. But that doesn't necessarily mean legally that it will be found to be mitigating or somehow be okay for that kind of language. So, absolutely. Yes. Check out that term magic words, because again, it's a legal concept that we use all the time. Yes. In California, yes. What about the state of California? It's the same. This is just a fundamental basic criminal law principle that we use. Now, some states define battery a certain way, some states define assault a certain way, and some states combine them. So you'll want to look for your statute because here we have, in Texas, they're combining assault as a battery and an assault. And an assault, again, is the threat. But in Louisiana, they split them apart. An assault is that attempt, and the battery is the unwanted touching itself. So it will depend on your jurisdiction about how they define assault and battery. And again, just as an example for laws involving language that can be charged criminally. define a person. Well, our statutes define people differently, so it depends on which statute you're looking at. How old are they? Are they a citizen? Are they not a citizen? I mean, there's lots of different elements involved in defining a human, again, depending on which code section you're looking at. As far as this goes, ask the people, not the court. Well, I mean, the people are the ones that wrote it, right? Because we elected representatives and they wrote this law. So we've already spoken. Now it goes to the court to determine if the law we wrote has been followed or broken. Laura, that's how our system of government works. I mean, that's just, there's not one person that wrote the criminal code. It was our elected representatives that wrote the code. These are how the laws are written based off of who we elected. I suppose that could be. Some people may feel that way. But again, we just have some basic fundamental understandings. We elect people, they represent us, they write the laws. Oh, I would not imagine for one moment that anyone here is an idiot whatsoever. I think, we all just learn and know things differently. That's all. Is the First Amendment state and federal enforced? Yes, it is. It is. It has all of the elements of the First Amendment have been incorporated through multiple different doctrines. So it does apply to the states. Can the criminal code be changed? Absolutely, it can. It's changed by our legislature. This is the federal code, so Congress would change this. But if Florida wanted to change their definition, their Florida General Assembly would come in and make the change. So this is all based off of our represented elected people. They can come in and change the code at any time, depending on, how things go, which is a lot of what's been going on lately. So thank you. Oh, you're welcome. Jury nullification is something that can be utilized in certain situations. Elections matter. Absolutely. Absolutely. Because those are the people writing the laws. The judges come in again and say, hey, this was broken or this wasn't done correctly or it was written poorly. They can do that. But it's our elected officials that are writing this law. So if you want your assault to be defined different or you want your speech to be protected better, it's your elected people that are deciding this. These are the ones that make that decision. Oh, you're welcome. You're welcome. Depending on how, well, I mean, I guess it depends on who's in charge in your General Assembly. There are plenty of legislatures that are run by Republicans. There's plenty that are run by Democrats. And then it has to be agreed upon by the governor. And the governor can be a Democrat or a Republican, depending on your state. So I think it's really kind of an amalgamation of all of those things. So do so much. Oh, you're welcome. You're welcome. I'm hoping that's helpful for you in order to really understand these basic pieces that I think they just slip through the cracks is all. I think there's no negative intent. I think they just kind of slip through. And honestly, I don't know what people are missing until someone tells me, like, hey, what's this all about? And that I'm so thankful for that, because then I can come on and talk to people about it and just kind of clear it up a little bit. Every U.S. citizen is their proof of intent to incite to every... Well, that's not really how that works. We just need to look at the people who were present at that day and at that time when that crime was charged. So that's all that they're looking at. So, and then anyone who is being negatively affected by that proceeding being hindered for 6 hours. So that's really what that's about. Fox News conspiracy theories in the comments. Could be. I really don't pay attention to that. Maybe I should, but I'm not really sure what other people are talking about. Violence actually happened. They need to charge all. I think anyone who is part of a criminal activity should be charged. I don't think law enforcement should say, get your voter registration card out and tell me which party you're a part of, and I'll decide whether or not to arrest you. I think if you break the law, you go forward and you deal with those accountability moments. So, again, I mean, if you've got, I don't know who has their party just like on a t-shirt necessarily. Well, maybe some people do. Hold on, let me think for a minute. Let me walk that back. But if you do, and that's the only reason why law enforcement's charging you, then law enforcement's out of line. Yes. I got them. Well, I'm just here to try to educate. There's so much going on with the First Amendment discussion. We can't have people's votes being thrown out. True. Absolutely true. And no matter what state, no matter what area of the country you're in or what kind of election, those votes need to be counted. That's what our country's all about. So that's really essential. Yes, I will do my best to keep educating. There was just a brief filing today. It didn't seem to have much of a significant effect, but there was one new filing that came out in DC just, for timing and so on. So I probably won't be taking any time of that to go through that. But, thank you. Yes, the next Red Pen Jamboree, which reminds me I should... Oh, yes. Oh, okay, I will. I'll take a look. Yes, I do. I try my best. I do absolutely try my best to just be clear on everything. So I will go ahead and hop off. I am scheduled to do a live later today on how to find the truth, the legal truth in things. So if anyone's interested in that, please join me here in just a little bit. I'll be going through how you determine whether or not something is true or not legally, and the different rules and so on that we use to make those determinations, which I think are so important. So it's 7:00 Central Time. And yep, 7:00. And I'm just going to be going through the rules of evidence and the sources that we use to determine credibility, expert testimony, and how we decide if a source is legitimate or not. So yes, I will be going through all of that later on as per scheduled. So hopefully this was helpful, and thank you everyone for joining me. I will see some of you maybe back later, and this will of course be posted up to my Tube of You channel for anyone who has been interested in seeing that. So, okay. Oh, thank you so much. Is it Luvi? Am I saying that right? Thank you so much. I appreciate that. So kind. Yes, you're welcome, Amy. You're welcome. And KJ's fabulous. That sounds wonderful. Yep, we will be going through legal truth sources and kind of talking about that. So see you all in a little bit. Oh, thank you so much. Oh, thank you. I appreciate that. So take care, everyone.